Hello to everybody taking gender-based violence on campus. This week, we are going to be talking about legal issues, particularly the Clery Act, Title IX, and the Campus Save Act. And so I wanted to give you some introduction to those issues to set the basis for the discussion that we'll have in the upcoming week. And this is obviously a very timely topic. A lot of those changes in the law are happening now. And so um, it is something that I think it can be important for us all to know, and you can educate others that you know about all these changes, hopefully from taking this class. So let me sketch out for you a timeline for the passage of the Violence Against Women Act. And particularly the most recent version, and set some terms out for you. The Violence Against Women Act originally was passed in 1994, and that addressed many issues of violence against women in the United States. Now, the most recent amendments to the Violence Against Women Act are called the Campus Save Act. And so when you hear the Campus Save Act, that's where it comes from. It's the amendments to the Violence Against Women Act that passed recently. There has just been a complex process of passing the new Violence Against Women Act and then enacting that into some specific rules. So the timeline there, on March 7th of 2013, the Violence Against Women Act reauthorization passed with the Campus Save Act as amendments. And then what happened starting April 1st of 2014, there was a negotiated rulemaking period that ended. And so that's something that went on for about a year. What negotiated rulemaking essentially is taking a law and then operationalizing that into specific requirements that in this case colleges and universities need to meet. Um, the That process tends to involve many different stakeholders in many different nonprofits and other sorts of places that all gather and negotiate and need to come to a consensus on what are these rules going to be, or what would they recommend that the rules would be to make the law have some teeth and actually go into effect. So after April 1st, there was then a period of public comment, and that allowed anyone to give ideas on what the latest version of the Campus Save Act should include. And then the Office of Management and Budget needed to approve it. And then finally, what happened in late October of 2014 was that there were regulations that came from the U.S. Department of Education that were the final rules. End of process. And so those came out, like I said, end of October 2014. And that is sort of the end of the process of enacting the latest version of the Violence Against Women Act and the Campus Save Act. So a lot of things came out in those negotiated rules, and I'll go over some of them. One is that any institution that uses federal financial aid or any other federal funds, which essentially is almost all but literally a handful of universities throughout the United States, has to meet the requirements of the Campus Save Act. And so several of those include the fact that each institution has to put in writing what their available programs are for domestic violence, dating violence, sexual assault, and stalking in their annual security report. And their annual security report is something that is always available online, well, usually online, but it has to be made available by the campus. And in that report, campuses have to state what procedures they follow when crimes are reported, the standard of evidence to determine responsibility, and then possible sanctions through the conduct process at a university for rape, acquaintance rape, domestic violence, dating violence, sexual assault, and stalking. So all of that is in there. Now, the another area that the Campus Save Act speaks to is procedures and options for survivors. And the Campus Save Act mandates that that survivors need to be presented with options that include preserving evidence, who they can report the crime to, options that they have with both the police and the university conduct system. They can request assistance from someone on campus and going to local police if they wish. They have the option to refuse police reporting, and then their survivor rights and responsibilities regarding protection orders, no contact orders, restraining orders, whatever the particular university term is that's relevant. And of course, the Campus Save Act also mandates that data has to be collected and reported on sexual assault, domestic violence, dating violence, and stalking. And the Act sets out definitions that campuses need to use for their what's commonly referred to as their Clery report, and that's something on the docket for our discussion this week is the whole Clery Act and what that includes. Now, what that's included for quite some time is the campuses needed to report the various different crimes that can occur on campus, liquor law violations, assault, other sorts of things. And the Clery Act made sure that sexual assault was included in the list of things that universities need to report. And the most recent version, through the Campus Save Act, added domestic violence, dating violence, and stalking to that to the report that universities have to file. Now, the intent of the Clery Act was that colleges and universities would put in a report what crimes occurred on their campuses, and then prospective students and presumably parents of prospective students would then be able to look at the Clery reports of different universities and give them information on how safe a university was to attend. The intent, though, doesn't always equal the effect, both in this case and in others. So, one of the things that we know from sexual violence research is that about 5% of rapes are reported to campus authorities. So a Clery report at best is only going to have 5% of the cases that occurred. So from my own point of view, the opinion I would offer to you is that the Clery reports do very little to provide any information that's useful, at least in terms of sexual violence, and can even provide a false sense of security because they may say, oh, well, we had 2 rapes this year, 4 rapes this year, whichever, which in the context of a 40,000 student campus can seem small, but it grossly underestimates the degree to which this actually happens. I think it's much better to do a climate survey that is scientifically rigorous and report those results, because then you're going to get a real better sense of what's going on in the campus. But, the law doesn't always go with research. The new Campus Save Act also includes educational programs that they need to promote awareness of rape, acquaintance rape, domestic violence, dating violence, sexual assault, and stalking, and that there also have to be primary prevention and awareness programs that are required now to be provided for incoming students and new employees. What the law didn't say is you have to keep track of who attends and you have to verify that every single person does attend. But at the same time, it says those programs have to be provided. In one of the sessions that occurred recently with the U.S. Department of Education, open public session, they were asked, well, what does it mean to provide these programs if they're not required attendance? And essentially what the Department of Ed said is, colleges need to make a good faith effort that students and new employees go. And so how that is interpreted is, I think, a matter of consternation perhaps on the part of some, but at the same time, you can't just simply say, hey, we're doing a program about sexual violence, anybody wants to come can come, and then have 2 people show up. So it needs to be a good faith effort to actually get them to be there. So let me say a little bit more here about Campus Save. They do require a prompt, fair, and partial investigation of cases, annual training for investigators and hearing officers about the various crimes the Act speaks to, and There's also now a new provision that both parties to a sexual violence case have the same opportunity to have others present during a proceeding. That came out of the concern that there were many different conduct processes that would allow a accused perpetrator to bring in an attorney, but the survivor had no representation, and so that particular aspect was designed to address that particular issue. So, and there are lots of other things with the Campus Save Act to know. I'd encourage you to go online and look at it. It's a interesting document and one that's worthwhile, I think, for us all to know about. Now, Title IX, which is the other topic that we're talking about this week, that, of course, came out and was decades ago, and the original intent was not necessarily that it only applied to athletics. However, that is where most of the attention has been in making sure that both men and women have equal opportunity to athletic programs. However, Title IX is much bigger than that. It involves making sure that there's no discrimination based on gender for individuals to get an education. So um, it's something that is increasingly being used in the last few years in sexual violence cases. I think that's a welcome addition to how sexual violence is being considered on college campuses. And in fact, um, when you are attempting to show a Title IX violation, the standard there is that you have to show that a sexual act of violence it was two things: unwelcome and offensive. So that could be sexual harassment, it could be sexual assault, whichever. It's actually, there are a lot of people out there, including myself, who believe that it's much easier and better to go through a Title IX process where the standard is unwelcome and offensive than the latest trend of having a yes means yes standard. And a yes means yes standard, which is a new California law, and others are actively considering it, is I don't think there are very many people to argue against that as essentially good practice in intimate relationships that people choose to engage in. At the same time, when it's put into policy or law, it can complicate matters because it's a different standard than the Title IX standard. And to prove that there was a willing yes is sometimes actually more difficult than the unwelcome and offensive standard. So that's just an issue I think that's worth thinking about. So lots we have to talk about this week in terms of the Clery Act and Title IX and Campus Save, other legal issues. I look forward to a vibrant discussion and for us learning from each other as we hash some of these issues out. So let's have a great week.